Let's talk about evidence. In the courtroom, evidence is the lead actor. Without it, you've got a lot of dramatic gesticulating and very little else. Today we're diving into the Qanun-e-Shahadat Order 1984, which governs evidence in Pakistani law. We'll dissect different types of evidence, from the smoking gun to the, well, that suspicious variety. Buckle up, because things are about to get legally interesting. Let's kick things off with the VIP of the evidence world, original evidence. This is the Beyoncé of proof, the top dog, the main event. We're talking about the original documents themselves, folks, not copies, not scans, not your cousin's hazy recollection of what the contract might have said. We want the real deal, the genuine article, with all its original signatures, coffee stains, and hastily scribbled side notes intact. Original evidence is considered the most reliable because it's the least likely to have been tampered with. It's the document that was actually signed, sealed, and delivered. It's the blueprint for the entire case, the foundation upon which everything else is built. But here's where things get tricky. What happens when the original document goes missing? That's where our next category comes in. Unoriginal evidence. For now, just bask in the glory of the original document. So, remember that goat I mentioned earlier? Sometimes original evidence goes missing. Documents get lost, destroyed, or end up in the hands of someone who'd rather not share them with the court. And when that happens, you've got to call in the understudy unoriginal evidence. Now, before you start picturing a second-rate mime troupe trying to recreate a legally binding contract, let's be clear. Unoriginal evidence isn't inherently bad, it's just different. We're talking about copies, certified copies, even oral accounts of what the original document said. It's not ideal, but sometimes it's all you've got. The court has to be convinced that the original document is truly gone, and the unoriginal evidence has to be presented in a way that's deemed reliable. A photocopy might be sufficient in one case, while a sworn affidavit from a witness with a photographic memory might be necessary in another. When done right, unoriginal evidence can be a powerful tool in the fight for justice. Let's move on from the world of dusty documents and into the realm of eyewitness accounts, where the drama unfolds right before our eyes. Because it's time to talk about direct evidence, the kind that leaves no room for doubt. This is the kind of evidence that gets straight to the point, no detours, no scenic routes, just a beeline for the truth. It's the kind of evidence that can make or break a case. Imagine this. You're walking down the street when you see a man in a striped shirt stealing a banana from a fruit stand. The scene is vivid, the details are clear. You saw it with your own two eyes, the thief, the banana, the bewildered fruit vendor. Every element of the scene is etched into your memory. That, my friends, is direct evidence. It's the kind of evidence that can sway a jury, that can turn the tide in a courtroom. It's evidence that directly proves a fact in question without the need for any fancy inferences or leaps of logic. It's the eyewitness testimony, the security camera footage, the kind of proof that leaves no room for ambiguity. The confession scribbled on a napkin in lipstick. These are the pieces of evidence that speak volumes, that tell a story without needing interpretation. Direct evidence is powerful because it's based on personal knowledge or observation. It's the kind of evidence that can make the difference between a conviction and an acquittal. It's not hearsay, it's not conjecture, it's not second-hand information. It's the real deal, the first-hand account. It's someone saying, I saw it with my own two eyes, and here's what happened. It's the kind of testimony that can be the cornerstone of a case. Direct evidence is the star witness, the one everyone wants to hear from. It's the kind of evidence that can bring clarity to a case, that can illuminate the truth in a way that no other evidence can. Sometimes you just need to see it to believe it. In the world of law and order, seeing is often believing, and that's where the magic of real evidence comes into play. And that's where real evidence comes in, the tangible, touchable, occasionally smelly star of the courtroom. It's the kind of evidence that you can physically interact with, making it a powerful tool in the pursuit of justice. We're talking about the physical objects that play a role in a case, the things you can hold in your hand or at least present to the court with a pair of tongs. These items are often the silent witnesses to the crime, holding secrets that can unravel the truth. Think murder weapons, stolen goods, or that banana I mentioned earlier. Each of of these items has a story to tell, a piece of the puzzle that can make or break a case. These are the objects that have a story to tell. If only they could talk. They are the silent narrators of the crime, waiting for someone to interpret their significance. But since they can't, we have lawyers to do the talking for them. These legal professionals are skilled at weaving the narrative that these objects represent, turning cold, hard evidence into compelling stories. Real evidence isn't always glamorous. It's not always the flashy, headline-grabbing items that make the news. It's more like presenting a dented car bumper as evidence of a hit and run, or a bloody glove as evidence in a crime. These seemingly mundane items can be the linchpin in a case, providing the crucial link that ties everything together. But even in its more mundane forms, real evidence is crucial because it provides tangible proof. It's the kind of proof that can be seen, touched, and examined, making it hard to refute. It's the physical manifestation of the crime, the thing that connects the dots and brings the case to life. Without it, the narrative remains incomplete and justice may remain out of reach. When presented correctly, real evidence can be incredibly persuasive. It has the power to sway juries, convince judges, and ultimately deliver justice. In the end, it's the clunk of real evidence that often seals the fate of the case. Sometimes the legal system is less about smoking guns and more about wisps of smoke that might suggest a gun was once in the vicinity. And that's where circumstantial evidence comes in, the Sherlock Holmes of the evidence world, piecing together clues and drawing inferences. Circumstantial evidence is all about connecting the dots, even when those dots are spread across a Jackson Pollock painting of a crime scene. Imagine this. You're a detective investigating a robbery. You don't have a confession, you don't have the stolen goods, and the security camera footage is about as helpful as a chocolate fireguard. But what you do have is interesting. You have footprints outside the window that match the suspect's shoes. You have a receipt for a crowbar purchased the day before the robbery. None of these pieces of evidence definitively prove the suspect committed the crime, but taken together, they paint a pretty compelling picture. And finally, we arrive at personal evidence, the category that proves that sometimes the best evidence is just a good story. This is the evidence that comes directly from the horse's mouth, so to speak, or at least from the mouths of those who witnessed the events in question. We're talking about eyewitness accounts, expert opinions, and the sworn testimonies of those who have something to say. It's the evidence that relies on human memory, perception, and the occasional dash of dramatic flair. Now, personal evidence can be compelling, but it can also be as reliable as a chocolate teapot in a heatwave. Memories fade, biases creep in, and sometimes people just plain lie. But when corroborated by other evidence, personal evidence can be the key to unlocking a case. It can provide context, motive, and that all-important human element that can sway a jury's opinion. So there you have it, the wild world of evidence, from the concrete to the circumstantial, the tangible to the testimonial. So, as we've learned, the concept of evidence is about as old as time itself, or at least as old as the concept of arguing over who stole whose goat. From the earliest days of human civilization, disputes have always needed resolution. And over the centuries, two main principles have emerged: the inquisitorial and the adversarial. These principles have shaped the way justice is pursued and delivered across different cultures and legal systems. The inquisitorial principle is all about a proactive judge, digging for the truth. They question witnesses, examine evidence, and basically take the lead in uncovering the facts of the case. This method is often seen in many European countries, where the judge plays a central role in the investigation. The adversary principle, on the other hand, is like a legal tennis match, with each side presenting their arguments and evidence, with the judge as the referee, ensuring that the rules are followed and maintaining order in the courtroom, and the lawyers volleying evidence back and forth. This method is prevalent in countries like the United States and the United Kingdom. It's up to the parties involved to find the evidence, present their case, and try to convince the judge or jury that their version of events is the right one. No matter the approach, one thing remains constant. Evidence is the cornerstone of any legal case. Without it, the pursuit of justice would be a mere guessing game. It's the foundation upon which justice is built, providing the necessary support for legal arguments and decisions, the key to unlocking the truth and, occasionally, the reason for a very long and complicated trial. The process of gathering and presenting evidence can be intricate and time-consuming. So next time you find yourself pondering the intricacies of the legal system, remember the power of evidence. It is the silent force that drives the quest for justice, ensuring that the truth is revealed and fairness is upheld.